the University of Toledo, and particularly to Professor Strang for inviting me here today. And I'm really delighted to talk about what I consider this hugely important subject in constitutional law. I don't really, I guess, need to advertise its importance. It's very rare for the President of the United States to denounce a Supreme Court decision in his State of the Union. And while, as we'll see, I don't entirely agree with once Professor, now President Obama on this subject, I do think it's a very important subject because unlike many constitutional law issues, which are important in their discrete area, campaign finance affects the nature of elections and so affects the scope entirely of law. And importantly also, I think it's a very important question of a deep division between two aspects of our system of governance. It raises really conceptually deep and politically consequential and I think persistently divisive questions because it highlights a fundamental concept within liberal democracy. Although some have seen liberal democracy as a coherent and stable state to which history is inevitably tending, the concept contains within itself an inherent tension, the relative priority between liberty and democracy, that is, between voluntary and spontaneous ordering, liberty, through the rights of individuals, and top-down ordering of democracy through the state. Giving priority to liberalism puts rights at the center of a regime. Under this view, I think, the exercise of free speech rights generate a civic order on which democracy rests, but which it must not disturb. And giving priority to democracy, in contrast, puts the authority of the people to govern themselves at the center, even at the expense of individual rights. And I think that is the debate that's really going on in campaign finance. And debate at election time raises that conflict between speech rights and democracy in its most acute form. Democracy, of course, gives every citizen one vote with equal consequences at the ballot box. The First Amendment gives each citizen an equal right, but that necessarily has different consequences because citizens have different kinds and different amounts of influence. In other words, democracy gives everyone an equal vote, but freedom inevitably leads to unequal voice. Now, how are we to resolve this tension? I don't think there's any easy philosophical way to do so. And my argument today is that the majority of the Roberts Court is resolving it through the ordinary operation of law. That is, it's applying settled principles of First Amendment laws in other contexts to the campaign finance context. The dissenters, in contrast, want to make campaign finance a law unto itself. This is a positive thesis. It's really an explanation of why the 7 campaign finance cases have come out as they have, that it's the weaving together of settled First Amendment doctrine. I also have a normative thesis that is right for the Roberts Court to decide these cases under what I'll call neutral principles. And finally, I'll respond to the most prominent attack on the Roberts Court campaign finance jurisprudence, that of Professor Larry Lessig of Harvard Law School. So let me begin with my positive thesis. It's demonstrated, in my view, at every level in the debate between the majority and the dissents, First Amendment doctrine, First Amendment test, and the nature of the First Amendment. Always the majority, I think, is moving campaign finance towards the web of the rest of First Amendment law. Let me touch on a few of the salient. I could spend a lot more time on all of the doctrinal points, but I'll just spend time on a few of them. Let me begin with one that actually isn't raised directly by the cases, but it illustrates what I mean by the application of neutral principles in First Amendment law. Came up in dinner last night. It's often said by people who are interested in having more campaign finance restrictions that there's no problem with this because money is not speech. Therefore, we can prevent someone who'd like to spend a lot of money urging the election of his or her candidate at an election. That, I think, it cannot really be an argument under neutral principles of First Amendment law. I think everyone would agree if suddenly the government said that the New York Times or newspapers in general could only spend a certain amount on investigative reporters to investigate candidates, that would be unconstitutional if they limited the amount that could be spent. And yet that, of course, is a restriction on money. The reason that it's also a First Amendment violation, besides being a restriction on money, is that restriction is targeted at speech. It falls on money, but there is a reference to speech. We're focusing on money related to investigative reporting, just as we're focused if we wanted to prevent people from speaking using getting advertisements on the radio for their particular candidate. We'd be focusing on their speech, just not on their spending money. So let me go now and talk. So that's an example of why that's wrong if we want to apply the First Amendment neutrally. So let me give another example, and I'll begin with the most controversial of the campaign finance decisions, Citizens United. I'll just very briefly state the facts of Citizens United. That's a corporation. It was a nonprofit corporation, people who came together and wanted to speak out in election and had a video in which they said not very pleasant things about Hillary Clinton in 2008. And it was alleged, and indeed this violated the McCain-Feingold Act, which said that corporations could not spend money to advocate the defeat or election of a candidate shortly before an election. And so one of the central issues in the case, indeed the most central issue, was did corporations have the First Amendment right to speak out around an election? And so the question was a debate over the rights of corporations. It struck me that the Roberts Court did exactly what it should do in this case. It looked at other cases in the First Amendment. Do corporations have rights? And universally, they do have rights under the First Amendment. Let's begin, for instance, with a landmark case like New York Times versus Sullivan, which protects newspapers against libel suits. That, of course, was a protection of a corporation, the New York Times. But that's not the only case. There are 30 or 40 cases, even in modern times, in which the court has protected corporations, and it's not been limited to media corporations or to political speech. For instance, commercial speech cases extend free speech rights to advertising, and other commercial matters largely stem from lawsuits by corporations. Thus, given the court's really enormous case law under the First Amendment providing protections to corporations in all contexts other than campaign finance regulation, it would be anomalous to deprive them of those protections in the electoral context. I mean, I think this also is very consistent with the language of the First Amendment itself. The text and structure of the First Amendment doesn't distinguish, as a matter of text, between associations and individuals. The First Amendment is unambiguously phrased as a prohibition on Congress about bridging the freedom of speech. It makes no distinctions among the kinds of entities that are exercising freedom of speech. Thus, I think the original public meaning doesn't lend any support to depriving corporations of the right to speak at election. Moreover, the logic of the First Amendment, I think, supports this kind of analysis as well. It undermines, I think, any distinction between individuals acting alone and through the organizations they form, including corporations. After all, we know from corporate law, a corporation is a kind of nexus of contracts, not unlike a partnership, by which individuals make their actions more effective than they would be if they acted individually. If under the First Amendment an individual has the right to speak, why doesn't a partnership or other association of individuals also enjoy that right? And if a partnership or association has that right, why does it lose it upon taking corporate form if it agrees that the corporation can act on its behalf? Given the First Amendment right also indeed contains a right of assembly, joint action to speech seems to fit comfortably within the First Amendment, as comfortably as with individual action. And then finally, I think the First Amendment's purpose is very well served by permitting citizens to use mechanisms such as corporations for concerted action generally, if it gives them more effective speech rights. individuals are relatively powerless against the state. The state is a very large entity, and to make their message heard when acting, it seems to me very much in keeping with the purposes of the First Amendment. Together in associations, whether partnerships, nonprofit or for-profit associations, they have a bigger megaphone, a larger capacity to persuade others about issues that concern them. So notice what I've done here. I've suggested that Citizens United is not only very well established, the idea of the rights of corporation in First Amendment law, it also seems to me to be very well established in the nature of the First Amendment. And that's the kind of argument, I think, that shows the Roberts Court is acting relatively neutrally when it comes to its decision in Citizens United. So let me move, that was a sort of doctrinal point, but let me move to tests under the First Amendment. The First Amendment is a variety of doctrinal tests that tries to, generally these tests, try to make sure that the legislature is not suppressing speech under some other sort of claim. It may be claiming that it's doing something in the public interest, but we have a variety of tests on the First Amendment because of our suspicion of legislatures that try to prevent them from suppressing speech under the guise of doing something else. So most of the decisions of the Roberts Court are about what are called in campaign finance law expenditures, and that's what Citizens United was about, the right of a corporation or an individual to spend money at election time to say who he or she or the corporation thinks should be elected, or to make some position on an issue at election time. There's also a portion of campaign finance laws that are actually about contributions to candidates. And while the Supreme Court has been very skeptical there really are any legitimate purposes in preventing people from speaking about who they'd like to see elected, there are some reasons you might restrict the amount of contributions you can give to a candidate. The reason is that too high a level of contribution might give a rise to suspicion of what's called a quid pro quo, or corruption in the system. And so there are a variety of restrictions of individuals and how much they can contribute to individual candidates. I think at the moment it's around $2,400 or $2,700 to an individual candidate. The Roberts Court case on campaign contributions did not concern these individual limits. It concerned total limits. There are additional limits that say that a citizen can't contribute more than, I think it's around $30,000 to all candidates, even if he never violated the individual limits. And in the McCutcheon case, the court invalidated that. And why did it do that? Well, I think it did that because the government's justification doesn't meet a traditional test. So what was the government's principal justification for imposing this kind of aggregate limit? The government argued that otherwise a contributor could give to many candidates or committees that would then pass through their contributions to some particular candidate, thus evading the limit. So they would, by giving it to a variety of other candidates, some candidates could then help candidates who were in their party, and this would be a way of an individual to curry favor, a lot of favor, by giving a contribution that was above the individual limit. The difficulty here is that the First Amendment has long required that the government burden rights no more than is necessary, and the Roberts Court found the government could have used less restrictive alternatives to protect the individual campaign contribution limits. For instance, Congress could impose restrictions on the transfer of campaign funds among candidates or among political committees. Such a provision would prevent circumvention of the individual contribution limits without interfering with the donor's interest, his First Amendment interest in expressing support for a whole variety of candidates. So what here the court has done is applied what's called a sort of least restrictive alternatives test, which is familiar in First Amendment law. We see it all around First Amendment law. And we have that test for a reason, because unless Congress has taken, in the First Amendment context, the least restrictive way of burdening speech, we suspect that they may be doing it for other reasons. And that's why we strike down why they struck down this contribution limit. So here, and we see this least restrictive alternative test in areas outside campaign finance limit, outside campaign finance law and the First Amendment generally. And so the court applies in the First Amendment law. That's, I think, another example of neutral principles. Now, interestingly, in dissent in this case, Justice Breyer, I think, opens up another disagreement between the majority and the dissenters. The dissenters generally are Breyer, Ginsburg, Sotomayor, and Kagan. And his argument is that we really need to defer to Congress here, because Congress, here's what he says: these kinds of questions, while not easily answered, are questions that Congress is far better suited to resolve than our judges. Similarly, in Citizens United, when Justice Stevens was on the court, he said that campaign legislation was entitled to presumptive deference. Thus, on the standard of review in campaign finance regulation cases, the dissenting judges argue for deference. My problem with this is that this is wholly against the general view in the First Amendment. Outside of national security questions, maybe where the court has trouble evaluating justifications because it doesn't have any information, the court does not generally defer to legislative judgments about the need to curtail First Amendment freedoms. This decision not to defer is consistent generally with the standard of review in other constitutional rights contexts, not only the First Amendment. The whole reason we have judicial review is not to defer when we have a express right in the Constitution. But it seems to have particular bite in the First Amendment context, because the right of electoral expression is one that legislatures may particularly want to suppress, because it threatens the power and indeed their continuance in office. I think a good example of that, and yet another campaign finance decision, was the so-called Millionaires Amendment, in which the Congress said that if you spent a lot of money, of your own money, to be elected, your opponent's restrictions on contributions would be relaxed, so they could raise more money than you could. And I think there's a clear self-interest of politicians in that way. The one risk to incumbents is that some wealthy person will come and self-fund their campaigns. And so we see it actually examples of self-interest in the campaign finance space. Breyer's contrary argument that we should defer to Congress strikes me as like an administrative expertise claim. His contention is that members of Congress run for elections and thus are uniquely knowledgeable in determining the rules for regulating these campaigns. But this assertion focuses only on knowledge and ignores the interests of members of Congress. Incumbent members of Congress have a substantial interest in regulating campaigns to protect their incumbency. And given that the First Amendment singles out this right for protection, it suggests some distrust of the legislature. Deferring to the legislative expertise on campaigns, I think, is very problematic. What it does is it turns the First Amendment's charter of freedom into a delegation to self-interested legislatures. And we don't do that in any other area of First Amendment law. I think the most striking aspect of the debate between the dissenters and the majority in the Robert Court is the nature of the First Amendment. The justices in the majority in this case asserted the First Amendment was defined by its nature as a right exercised by private individuals and their organizations. Thus, for the majority, the government's interest in perfecting democracy and making it work better doesn't help define the nature of the right, but it's only evaluated to see whether it's strong enough to be a compelling interest. In contrast, in McCutcheon, Breyer argues for the dissenters that the First Amendment is in part, quote, a collective right, because it's designed to connect the legislatures to the sentiments of the people. Such government interests shouldn't be measured to be weighed against the constitutional right to political speech, he says. Rather, they are interests represented in the First Amendment itself. That, I think, is a very radical view that's completely different from the way the First Amendment doctrine has always worked. as the majority shows, the government's interest is only weighed at the level of a compelling interest to abridge the right. Now, there's some interests that may be compelling, interests you can't publish troop movements, and there are various other interests that are thought to be compelling enough to abridge speech, but they're never part of the First Amendment itself. And so that, I think, strikes at the heart of the nature of the First Amendment. Breyer, what is Breyer's argument on the other side? And here again, I think it shows the problematic nature of some of the opponents of campaign spending. What he tries to do is look at the original meaning of the First Amendment. But some of what he does here is just really striking, and indeed, I think almost, how can one put it, in a nice way, comes up against the bounds of honesty. Justice Breyer, for instance, offers some statements from the founding era to support his view that the First Amendment embodies a collective right. Well, first he quotes snippets from the lecture by James Wilson on the Constitution, where he purports to demonstrate, and here I quote, Wilson believed that, quote, the First Amendment would facilitate and then he quotes from Wilson, a chain of communication between the people and those to whom they have committed the exercise the powers of government. But actually, this quote from Wilson doesn't appear in a discussion of the First Amendment, as Breyer implies, but in a discussion of the novelty and virtue of representative government, as opposed to what Wilson calls monarchical, aristocratical, and democratical forms of government. Wilson here is rejecting direct democracy, and he specifically notes in this very discussion the necessity of a legislator's freedom to vote at variance with the sentiments of his constituents. So far from talking about a connection between the sentiments of the constituents and the legislature, in this context, which has nothing to do with the First Amendment, he's celebrating the ability of the legislature to do the opposite of what his constituents want. And indeed, not only does this phrase have nothing to do with the First Amendment, the term here, communication, is used to mean voting, not expression. That's clear from the next sentence in this passage, a sentence which Breyer fails to quote. The chain may consist, he says, of one or more links, but in all cases it should be sufficiently strong and discernible. In the context of discussing electoral representation, Wilson's meaning is that representation may be direct, one vote between the people and the choice of the representative, but it also may be indirect, like the Constitution's own establishment of the Electoral College, where we have an indirect way of election. At least two votes, therefore, are between the people and their choice of representative. The chain is longer. Justice Breyer has committed, seeming to me, a cardinal sin of historical research, failing to understand or even to supply to the reader the context of a quotation. Perhaps as bizarrely, in my view, Breyer finds support for his claims about the meaning of the First Amendment in Jean-Jacques Rousseau and his notion of the general will. But Rousseau has little, if any, influence on any provision of the Constitution, let alone the First Amendment. And the founders did not have a high opinion of Mr. Rousseau. John Adams, for instance, called his theories mad, bad, and dangerous. For that reason, he's never been cited in a majority opinion of the Supreme Court with such justification. That's Justice Breyer's efforts to try to create, I think, some neutral principles are alternately misleading and silly. It really shows, I think, that if Justice Breyer wants to do originalism, he needs an originalist law clerk. So why does it matter that the Roberts Court is applying First Amendment law in other contexts and general neutral principles? So why should that be so important, and why does that justify what it's doing? Well, here we have to look about the importance of applying neutral principles to law. And that becomes central to American constitutional jurisprudence in the 20th century. Precisely because the Supreme Court exercises a more robust power of judicial review than at previous times in its history, it had to establish its legitimacy in overturning the judgments of political branches. And one source of that legitimacy was the nature of its decision-making. In defending the Constitution, it was not supposed to act in the ordinary ad hoc manner of politicians, the way you see them changing with the winds, it was supposed to render decisions according to reasoned elaboration of settled principles. It cannot select, so that's what neutral principles therefore require whatever rationale a court selects to justify its chosen interpretive doctrine must be applied consistently in all cases. That's the quotation from my colleague, Marty Reddish. Thus, a decision shouldn't depend on the identity of the parties or the nature of the dispute, but on the principles that transcend dispute and party. These neutral principles guarantee political neutrality essential in establishing the judiciary's comparative advantage in deciding cases in constitutional law as opposed to the legislature. And the requirement of neutral principles has particular purchase in the First Amendment for three reasons. First, while most constitutional disputes are about particular substantive results, the First Amendment disputes bear directly on the whole scope of the political process. Thus, if the Supreme Court doesn't apply neutral principles, it won't only be engaging in ad hoc decision-making in some little space, it will be distorting the entire nature of our decision-making, which is so dependent on free speech. Second, the First Amendment is premised on a view that the government can't be trusted with decisions about speech. But even though judges themselves are government officials, the court necessarily has to make decisions about how the First Amendment will apply. Given the special problems of trust in this area, the court has a particular need to make its decisions according to neutral principles, to make its method of interpretation reflect the underlying nature of the amendment. This is a general point. The more a constitutional provision reflects an economy of distrust, the more it requires judicial constraint that the adherence of neutral principles can provide. In other words, when there's reason to believe that trust in interpreting the law should be low, constraint on discretion becomes more necessary. And third, campaign regulations are conceived by politicians who have as one of their objectives re-election and defeat of their opponents. And of course, the Supreme Court is appointed by politicians, and that's another reason that they need to display their neutrality. And if there are more powerful reasons to apply neutral principles in campaign regulations, it's easier to do than in other constitutional contexts. Well, the court is, more than any other constitutional right in this century, has returned to the First Amendment again and again, laying down decisions in areas with less high stakes than campaign finance. And such principles forged outside the hurly-burly of politics should be applied in the area of politics as well. Therefore, it seems to me to count enormously heavily in favor of the Roberts Court jurisprudence that it follows neutral principles by uniting campaign finance regulation with the rest of free speech jurisprudence. That's the excellence of the Roberts Court. It's the application of neutral principle, and it's taking, I think, very consistently all of the decisions that it's made and putting them in a more general First Amendment context. So let me end by talking about the biggest critic, I think, the most famous critic of the Roberts Court, Larry Lessig. You may know him from Harvard Law School. In fact, he ran briefly for president, arguing that we really needed to change election law, particularly campaign finance law. He couldn't get in the debates and therefore ended his campaign on the Democratic side. His leading argument for restricting expenditures by citizens on election is that the framers believed that the government should be dependent on the people alone. As a result, according to Lessig, Congress can legitimately regulate campaign expenditures that prevent the distortion that would occur from permitting legislatures from being dependent on the wealthy rather than on the people themselves. That's the essence of his argument. By its logic, I think, Lessig's argument would permit Congress to regulate the press. Its power to distort opinion is surely as great or greater than the wealthy. For instance, there's evidence that the editorial endorsement of important newspapers like the New York Times can be actually decisive in local elections. But beyond its extravagant implications, his theory fundamentally misapprehends the way the framers of our Constitution understood democracy. The dependence of representatives on the people doesn't come from their being in sync with the opinions of their constituents on any set of issues, but on their getting most votes in periodic elections. It is striking that the Constitution does not include any mechanism of direct democracy, like a referendum, to connect policy more closely to citizens' opinions on particular issues. Indeed, the framers rejected the idea that representatives should be required to follow the instructions of their constituents. And I think for good reasons. people often take positions on one issue that are in tension, if not outright contradiction, with their position on another. Legislatures in our kind of democracy were empowered to sift opinions for aid in determining what they believe the right course of action, rather than to give equal weight to the views of each citizen. The First Amendment, and that is how the First Amendment fits into their understanding of democracy, was it itself guarantees not equality, but freedom. Rights by their nature are exercised to radically unequal degrees. A few people are articulate, but most are not. Some are wealthy. Others own or work for the media or academia. Still others command attention through their own celebrity. We've seen one of those in this campaign, right? Donald Trump. He hasn't spent much money. He has unequal influence because he's a celebrity. And still others command, but most of us have none of these advantages. Some citizens are so intensely focused on specific policies or particular political ideals, they join together to amplify their influence in a corporation or an association. But many people, maybe most, are pretty uninterested in the projects of government. Giving citizens freedom to use their very unequal endowments and positions in society to press their disparate interests necessarily means that the framers made a decision to let democracy float on an order of civic discourse unshaped by the government. No law can succeed in purging elections of the unequal influences of the press, of the articulate, of the celebrated, of the well-connected, or yes, the wealthy. Restricting one group will just magnify the influence of the others. The First Amendment is a direction not even to make such a delusive effort, because of the danger that politicians will deploy their power to preserve their prerogatives is greater than any of the dangers posed by inequality. Let me end in this way. Of all the provisions of our Constitution, it's the First Amendment that is given to the rise, I think, to the most majestic edifice of doctrine. In hundreds of cases, from disparate walks of life, commerce, art, politics, the court has teased out the logic of the amendment's underlying plan to protect a civic discourse created by individual choice, unfettered by government control, except in the most compelling of circumstances. Over time, that case law has also elucidated the weight of an interest that qualifies as compelling, and the burdens the government must shoulder in making its proof. Just as there is an inner logic of free speech doctrine that reflects the First Amendment's plan, there's also an inner temptation to distort its application. In the regulation of political campaigns, that temptation is at its greatest. The justices owe their high position, to choices of partisan politics that will be shaped directly by their decisions in this area. That temptation also is all the more powerful because by regulating the expression of ordinary citizens' campaign finance, regulation aggrandizes the influence of the press and academics, the citizens most responsible for determining the justice's reputation. It strikes me as an extraordinary act, therefore, of courage that the Roberts Court majority has escaped that temptation by recurring to First Amendment principles in contexts other than political campaigns. Those principles, forged over decades by justices of many different political parties, provide the assurance that the justices themselves are not acting to favor one party, one ideology, or even themselves. Thank you very much.
This has agreed to do questions for, we have 20 minutes, and so please raise your hand if you have a question. Provost Barrett?
I'm a little bit curious about your assertion that the founders, or an original intent argument, would be supportive of corporations engaging in this type of speech and being seen as speech. As you look back in the history of corporations, the further back you go, the more distrust of corporations you see. You see limited purposes. Corporations had to state exactly what they were going to do or risk running afoul of the ultra-virus doctrine. And what was an acceptable purpose was quite limited as well. Now, those have deteriorated over time. We have a much more robust sense that corporations may be people in the 21st century. But what specific evidence do you have that the founders would even have contemplated a corporation acting in the type of way that Citizens United did? I don't think, I mean, I haven't looked into it, I don't think Citizens United probably could have even been formed as a corporation when the founders were around.
Good question. Let me make 2 points. First of all, that argument, of course, could be made about any corporation, and throughout our law, we have very strong doctrine of the corporation of corporate personhood. As I've demonstrated, it's very powerful in the First Amendment law. So we have a doctrine of precedent that even if you were right, I think we'd still have difficulty in overturning that for the particular case of Citizens United. But I'm happy you asked that question because it allows me to talk about originalism, which is one of my real interests. And I don't think that the way you're suggesting we should do originalism is the way we should do originalism. The First Amendment is stated as a restriction on Congress. It isn't stated as a question of whether or not we should find evidence that they contemplated that some particular entity or some particular kind of group had the power to free speech. It's stated as the Congress shall not restrict free speech, as there's no suggestion that there's any restriction on the entity. And so many matters like that, we apply these principles even if they didn't imagine that they were going to be applied in a particular way. Of course, the framers didn't imagine the internet, and yet we apply the First Amendment principles to the internet. They may not have imagined the importance of corporations. They may not have imagined that the ultra vires doctrine would, because there, of course, would be no problem under First Amendment law if a corporation didn't permit campaign contributions. They put that in their bylaws. That would be a matter of corporate law, and that would be absolutely fine. So they may not have imagined that the ultra vires doctrines would disappear, but that's also, they didn't imagine the internet either. We should look at their words in the document, and their words are a restriction on Congress because of their distrust of the legislature, not a list of the particular entities that should or should not have free speech rights.
Can I follow up? Sure. I worry about that approach from this perspective that why would the founders write in the Constitution free speech pertains only to human beings if they wouldn't think that corporations would speak? It wouldn't have been in their thought process. They didn't write about dogs having, whether dogs have free speech rights either. Well, the fact that the words don't limit it, if the common sense and their understanding would have been only people speak, why would they have bothered to limit it?
But I don't think you can say, maybe if there was some tremendous argument in common sense, it was obvious that they would have wanted to limit it. That would be a kind of what would be called an expected applications argument. I actually don't see that kind of evidence that they actually thought corporations shouldn't have those rights. And as I've tried to argue, corporations are, after all, a group of people coming together. There is a right of assembly, a right of people coming together to speak on their own in partnership. So it's very unclear why you would draw the line at the corporate form, or why the logic of it is so clear that you would override the text of the Constitution, because they do make a decision not to make a distinction between the different kinds of entities that might speak.
Mr. Powell?
Yes. The question in this election many times has been raised about the role of churches and their free speech rights, and 501c3s who are concerned about losing their tax status if they endorse a candidate. So you'll have ministers who will say, I can't say from the pulpit that I'm in favor of Donald Trump or Ted Cruz or Hillary Clinton, because there is the possibility of the government that there's some repercussion from that, because I would lose my nonprofit tax status. To me, that seems another restriction that the government is putting on free speech, that I should be able to get up and say in front of my congregation if I was a minister that I'm in favor of this candidate or not, and I should even, in theory, be able to collect money for that candidate. So I'm just asking, where do you see this religious sort of piece in this?
That's, of course, is not is slightly different from campaign finance matters, but I think is an interesting question. I myself certainly don't favor that limitation on churches. I think maybe the defense of that is that they're getting the privilege of a tax deduction in response for that. I'm sort of a skeptic, and in other areas in modern constitutional law, we're quite skeptical of the rights privilege distinction. So I myself think that is somewhat doubtful as should be a restriction on churches myself.
Can I ask another question then?
Well, there's one. Okay. Then.
Just, I actually am the chairman of a federally registered political action committee. And we have a restriction as a federally registered through the FEC that we cannot accept campaign contributions from a corporation. Okay? And that seems to me, again, a corporation might want to give us money, but they can't. We can't legally accept it. Okay? We can only accept up to, I think, $5,000 from an individual. I'm just curious how now if you can become a super PAC, a different type of political action committee where you can take large amounts of money in. But it seems to me that the restrictions, that's why I'm kind of, what was interested in hearing what you had to say about Citizens United, because I don't know why I'm restricted.
Sure. Well, I think the reason goes to this distinction between, let me explain it. The reason goes to the distinction between expenditures and contributions. Expenditures, the thought is that there's very little justification for restricting independent expenditures because you don't agree with the politician. It's your voice. Maybe it'll help the politician, but there's no agreement in that context. And generally, the arguments that have been made for restricting independent expenditures are that there's some substantial concentration of money, of either the wealthy or that corporations have too much money. That's a kind of a quality argument, which I'm quite skeptical. We don't accept that generally in the First Amendment area. We don't find that a very persuasive argument. In the context of contributions, we are worried about the quid pro quo aspect and the perception of that you're going to get a favor in return. And I think the argument, at least you could make a distinction, is that for a corporation, precisely because it has some corporate purpose, not an ideological purpose, in donating money to a politician, that therefore their contributions could be more restricted than individuals. Because individuals, there's no reason necessarily to believe that they're seeking anything. They just may want to seek their vision of the good. A corporation, you might think, through general rules of corporate law, has to be seeking something on behalf of the corporation. I think that's why you might see a difference and why there still is restrictions on corporate contributions where there are not restrictions on corporate expenditures.
We're not a politician, we're a PAC. We are not connected, so, I'm just curious, but I understand.
The gentleman in the back, you have your hand up.
It seems to me that there are a few different things that get kind of bundled together: money, speech, and influence. And the way influence goes, it's very little that goes on in elections. It really goes on in day-to-day lobbying and persuasion at that level that's hidden from the public view in a lot of cases. And the lobbyists don't all agree with each other, but it seems to me that the emphasis on the campaign contribution stuff just ignores the biggest arena in which persuasion in government really takes place.
I think that's an excellent point. And one of the ideas that I have, important at it, is the First Amendment has this always burbling aspect of civic discourse, always going on. It just doesn't happen at elections. I mentioned Donald Trump showing us the power of celebrity, which I think anyone undoubtedly sees in this election. Also, I think shows how the media is often quite self-interested. I think the media has been building up Trump. He's great copy, right? He says outrageous things. It's wonderful, and why we should make a distinction between the media, which are for-profit corporations, and other for-profit corporations seems to me also very difficult to figure out under neutral principles. But your point, I think, is even a more powerful one. We think of persuasion is happening all the time. Persuasion is happening right now in this room, and through the questioners as well. in the academic world is always about persuasion. And I see that as connected to yet another powerful candidate in this election, Bernie Sanders. There's just no doubt that the academic world, we can look at, is monolithically on the left, and they've been monolithically on the left for 2 decades, and I think it's not surprising that we're seeing evidence of that in the views of young people. And so, should we restrict academics in their ability to promulgate their views? Absolutely not, in my view. But and I find it in some ways a little shocking and short-sighted that someone like Professor Lessig, who doesn't really understand that he has enormous influence as a professor at Harvard Law School in educating opinion leaders and lawyers for generations to come, doesn't recognize that he also has completely disproportionate influence. And if I may say so, to say be a little more controversial, you might more worry about the influence in the media and in academics precisely because it's so ideologically one-sided. Actually, if you look at money spent in elections, it doesn't turn out to be very ideologically one-sided. There are a lot of Republicans, a lot of Democrats, George Soros, Tom Steyer on one side, the Koch brothers on the other. So I think it's what you say is exactly right. It shows that we have to broaden the understanding of what influence is in elections. John Maynard Keynes famously said that a politician is reflecting the views of some defunct economist. Many voters are reflecting the views maybe of some defunct professor. And I certainly think we should recognize that. And I think that helps us understand why it's very problematic, I think, for academics to be arguing for restrictions on other kinds of influence when they enjoy, quite appropriately. We know, as I say, it's impossible to have equal influence, substantial influence in the burbling, ongoing debate that is our civic life.
Any other questions? Professor Davis?
Just listening along, John, help with this. I'd really appreciate it. To what extent, in those 3 words, freedom of speech, at the time, the concept of freedom was subscribed, the concept of who could speak was subscribed, that even in stating that, they actually had a very clear limit on who could speak and who could have freedom. Moreover, in the way they built their Constitution, they made sure that with the Commerce Clause blocking the limited federal government role in the interstate commerce, the Fugitive Slave Acts and all that stuff, they put in place a structure to guarantee the ability not to have certain people have freedom or to have speech. So that if there's a wolf in a woof of the whole thing as it's structured at the time, that only maybe with the 13th, 14th, 15th Amendment was kind of opened up to another group. So wouldn't that suggest, I don't know to me, that even in the words freedom of speech, there are limitations implicit from the time when they wrote it?
I think the limitations would come from, of course, clauses that have been quite repealed in the Constitution. They don't come, so it may well be that you would have had to read the freedom of speech in the context of other limitations, and so it's probably correct that enslaved people could not speak at the time. But that, I think, comes from, as you point out, the implicit inferences that you could make from other portions of the Constitution. I would want to emphasize, though, that the freedom of speech was an essential aspect of getting rid of slavery. As you sure know, that and the right to petition Congress, all of those rights were incredibly important to the abolition movement. So I don't think, the idea, if we try to think of what restricting campaigns on at that time, the whole gag rule was an attempt, right, in Congress to say you couldn't bring certain kinds of petitions. It was an attempt to restrict the speech of people. And I think Congress was interested for all sorts of self-interested reasons. So I actually I think just generally about the struggle for freedom for slaves, I certainly don't think it suggests that we should be any more enthusiastic about restrictions that Congress imposes. They have a lot of self-interest behind them, and the freedoms were extremely important in bringing the country, or bring many people in the country, to realize the evils of slavery.
We have time for one more question. Well, join me in welcoming Professor. Thank you, Professor.